This is civil litigation, not a criminal prosecution, and the lively parties are not the FBI. So to me, it kind of sounds like they're seeking information on at what time did they enter the bathroom to take a shit on any relevant day. Though numerous human resources complaints were raised regarding Mr. Baldoni's and Mr. Heath's behavior, Wayfair failed to conduct an investigation or to otherwise adequately address concerns or voluntarily implement protections for Ms. Lively or other cast and crew on set. Notwithstanding the Lively party's inexplicable refusal to consent to a similar extension requested by the Wayfair parties in the throes of the Los Angeles wildfires. Unfortunately, the Lively party's letter goes further than a simple request for an extension of time, leveling unnecessary and baseless attacks on non-party Jed Wallace. Now, I've had people get kind of mad at me in comments and stuff like that. We can have different opinions and even talk about those differing opinions and debate it without acting like a wide-open asshole. Hey everybody, welcome back to the Court of Random Opinion. My name is Neidigh, and I'm here to give you some updates on the Justin Baldoni versus Blake Lively legal cases that happened this past week. Blake Lively had requested an extension to file her amended complaint, and the judge has ruled on that. Justin Baldoni's response to Blake Lively's request for extension of time included an exhibit which showed all the accusations Blake Lively made against Jed Wallace. We'll be going through Blake Lively's petition for Rule 202 deposition to take a look at that. Additionally, Blake Lively and Ryan Reynolds filed subpoenas to get the phone records of Justin Baldoni and the Wayfair parties, and even some non-parties. But Baldoni's legal team has hit back with an objection. Now, as you guys know, I'm not a judge and I'm not a lawyer. I work in mental health. I'm a psych evaluator. When I talk about court cases, it's mostly just pure conversation and me giving opinions, and just trying to open up some discussion with viewers. So in my personal opinion, I can't understand why someone should have such broad access to someone's private communications, especially if it's with non-parties and it may not have any relation to the case at all. But let's take a look at Baldoni's response and see what they had to say. We also saw some interesting stuff come from Justin's former agency and the press. Let's get into it. Dear Judge, as counsel for Wayfair Studios, LLC, Justin Baldoni, etc., we write to raise a discovery dispute concerning flagrantly overbroad subpoenas served by Blake Lively and Ryan Reynolds. Earlier this week, the Lively parties issued subpoenas to cellular providers AT&T, Verizon, and T-Mobile, seeking all documents concerning ingoing and ongoing calls, I think they mean outgoing calls, unless somebody's still on the phone, or text messages related to the phone number, redacted, belonging to each of the individual Wayfair parties, some of their employees, and various non-party individuals, including but not limited to call logs, text logs, data logs, and cell site location information. That seems a little creepy. The subpoena seeks such information over a period of multiple years, in most cases spanning from December 1st, 2022 to the present. It is hard to overstate how broad, invasive, and atypical these subpoenas truly are. This is civil litigation, not a criminal prosecution, and the Lively parties are not the FBI. Yet the subpoenas seek not only the complete call and text history of each of the targets over a period of several years, no matter the sender, recipient, or subject matter, but also over the same period, real-time location information and data logs reflecting, among other things, web browsing history. So to me, it kind of sounds like they're seeking information on who each one of these people talked to, what they talked about, at what time, and then at what time did they enter the bathroom to take a shit on any relevant day. This would include, of course, materials protected from disclosure by a laundry list of statutes and privileges, among them the attorney-client privilege, the spousal privilege, and the physician-patient privilege. Moreover, the information sought by the subpoenas is wildly disproportionate to the needs of the case and unnecessarily invades the privacy of untold numbers of third parties, including family, friends, business partners, and quite literally, any other person with whom any of the targets have communicated with over a period of years. And, given the location data, depending on how precise, possibly any person they had any sort of public toilet glory hole interaction with. Obviously, I'm being intentionally dramatic here, but still, this is quite invasive. The Lively party's highly experienced counsel are surely well aware that the subpoenas they issued grossly exceed the scope of permissible discovery, as outlined in Federal Rule of Civil Procedure 26b1, which limits discovery to any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. Unfortunately, it appears that these subpoenas are, more than anything else, a media ploy, having been promptly leaked alongside a lengthy and combative statement by the Lively party's legal team. The Wayfair parties are not remotely concerned about the Lively party's public statement, however hypocritical, and do not object to their use of third-party discovery tools. The Wayfarer parties are using such tools themselves, albeit in a far narrower and legally permissible fashion. However, the Wayfarer parties are deeply concerned that the Lively parties are intimidating third parties into providing information about our clients and various non-parties far beyond what is appropriate or even legal in civil litigation, including spousal communications, medical information, attorney-client communications, and real-time location information, among other things. The subpoenas constitute a flagrant abuse of the discovery process and, if allowed to stand, set a precedent that, once their bluster dissipates, we are confident the Lively parties' counsel will not be prepared to accept when it comes to the scope of discovery into their own clients' private information and communication. This afternoon, we conferred in good faith via telephone with the Lively parties' counsel regarding the subpoenas, but were unable to resolve the dispute. This matter is highly time-sensitive, as certain of the cellular providers have already indicated they intend to comply with the subpoenas. The Wayfarer parties therefore request your Honor's attention at the soonest possible opportunity. Copies of the subpoenas will be filed under seal with the requested redactions, solely of telephone numbers highlighted. Pursuant to your Honor's procedures for sealed and redacted filings, we request that the court approve such redactions. Now, some people on one side or the other may say, like, oh, they don't want you to see that stuff because you're guilty. Well, I don't agree with that. I think any party would object to those subpoenas because if you're in the middle of a legal battle and you really dislike someone, obviously you're in the middle of a court battle with them. Why the fuck would you want them to see all your phone communications? These next couple filings are only, a few pages long, except for the deposition, which is a little bit longer, but we're just going to skim through the meat of these. Dear Judge, Plaintiff Blake Lively respectfully moves for an extension of time to file her amended complaint to March 5th. Defendants Blake Lively and Ryan Reynolds additionally seek clarification from the court that the deadline for any motion to dismiss is March 20th, 2025, or alternatively, move to extend the deadline for the time to file any motion to dismiss to March 20th, 2025. Counsel discussed the proposed relief sought in this letter with counsel for the Wayfarer parties on February 7th and additionally followed up requesting a position on February 10th. As of the time of filing, counsel for the Wayfarer parties have not indicated whether or not they consent. As addressed herein, the deadlines proposed above would apparently align the parties' deadlines across the cases and ensure they proceed on a concurrent track. Doing so is also warranted given that the Wayfarer parties asked for and have received extensions both before and after the conference with the court on February 3rd. This is Ms. Lively's first request for an extension of time to file her amended complaint as a matter of course, and this is the Lively/Reynolds parties' first request for an extension as to the motion to dismiss deadline. The parties' next appearance is scheduled for October 21st. The modest extension will allow for Ms. Lively to address the extensive new facts and claims at issue in this litigation. Such an extension is also warranted given that, after counsel for Ms. Lively informed the court on February 3rd that she intended to amend her complaint and add additional parties and claims, one of those intended parties, Jed Wallace, along with his company Street Relations Incorporated, filed an anticipatory and meritless 10-page complaint in federal district court in Texas regarding issues that substantially overlap with the issues in this litigation. The additional time requested will allow Ms. Lively to address properly the procedural issues arising from the unmeritorious lawsuit as well. Here was the response from Justin's side. Notwithstanding the Lively party's inexplicable refusal to consent to a similar extension requested by the Wayfarer parties in the throes of the Los Angeles wildfires, the Wayfarer parties have no objection to the extension sought by the Lively parties. However, if the court extends the Lively parties' deadline to amend their complaint to March 5th, the Wayfarer parties respectfully request that the court extend the Wayfarer parties' deadline to respond to April 16th. Unfortunately, the Lively party's letter goes further than a simple request for an extension of time, leveling unnecessary and baseless attacks on non-party Jed Wallace and the litigation pending against Ms. Lively in the United States District Court for the Western District of Texas. What the Lively parties conspicuously fail to mention is that the now pending litigation in Texas was precipitated by Ms. Lively, who initiated legal action against Mr. Jed Wallace in Texas State Court on January 21st, approximately 2 weeks before he filed his federal lawsuit in response. While the Lively parties now claim that Mr. Wallace's Texas action suffers from serious issues with respect to jurisdiction, venue, and claims, in Ms. Lively's verified petition seeking a pre-suit deposition of Mr. Wallace, Ms. Lively acknowledges that jurisdiction in Texas is proper, given Mr. Wallace's domicile. A true and correct copy of Ms. Lively's petition is attached hereto as Exhibit A. Notably, in her pleading, Ms. Lively concedes that she lacks sufficient facts to state a claim against Mr. Wallace, hence the need for pre-suit discovery. In addition, while the Wayfarer parties strenuously object to the Lively party's assertion that Mr. Wallace's lawsuit is meritless or unmeritorious, it bears emphasis that Mr. Wallace is represented by separate counsel in that matter, and he is not a party in any case before this court. Okay, so here are some of the things that stood out in this petition. On information and belief, Mr. Wallace has described himself as a hired gun and claimed a proprietary formula for defining artists and trends. On information and belief, Mr. Wallace specializes in executing confidential and untraceable campaigns across various social media platforms, including TikTok, Instagram, Reddit, and X, to shape public perception of his clients and their adversaries, and to perpetuate those perceptions by, among other things, creating social media accounts with inauthentic users. Should have just said botting. Though numerous human resources complaints were raised regarding Mr. Baldoni's and Mr. Heath's behavior, Wayfarer failed to conduct an investigation or to otherwise adequately address concerns or voluntarily implement protections for Ms. Lively or other cast and crew on set. Now, she's also said in another one of her filings that other cast and crew had raised complaints about Justin. I have not seen any of them. If anybody has, please let me know in the comments so that I can check those out. I do want to be able to cover, both sides of the story here. However, I won't lie to you, I find Justin's story more believable, given the evidence we've seen so far, which I'll admit is not everything because I wasn't there. None of us were there. It's not impossible that he did something that made her feel uncomfortable. It's just my current opinion. Starting on the day the film was released in August 2024, Ms. Lively suddenly became the focus of vitriol and negative commentary on social media and in the press. Ms. Lively later learned that the negative public sentiment that was suddenly unleashed against her was the direct and intended result of an intentionally seeded social manipulation, social media mitigation, social combat, and public relations scheme that was planned, implemented, and funded by Mr. Baldoni, Mr. Heath, Mr. Steve Sarowitz, Wayfarer's co-founder, and Wayfarer as unlawful retaliation against Ms. Lively for raising concerns about harassing conduct on set and in violation of multiple contractual agreements, including the writer's non-disparagement provision. Here it's outlining the alleged retaliation campaign, which we've seen in previous filings, so I won't go over that too much. The retaliation campaign relied on more than just publicists and crisis managers spinning stories. They also retained subcontractors, including Mr. Wallace, who weaponized a digital army around the country, including in New York and Los Angeles, to create, seed, manipulate, and advance disparaging content that appeared to be authentic on social media platforms and internet chat forums. The Baldoni Wayfarer team would then feed pieces of this manufactured content to unwitting reporters, making content go viral in order to influence public opinion. To safeguard against the risk of Ms. Lively ever revealing the truth about Mr. Baldoni, the Baldoni Wayfarer team created, planted, amplified, and boosted content designed to eviscerate Ms. Lively's credibility. They engaged in the same techniques to bolster Mr. Baldoni's credibility and suppress negative content about him. Now, I've had people get kind of mad at me in comments and stuff like that and say, like, you're just a sheep, you're eating up the stuff that Justin and his team are putting out into the universe, you're being foolish, I'm so disappointed in you, and shit like that. Like, all kinds of crazy shit. Like, hello. We're all just random members of the public. You do not know any better than I do. So to personally attack me, or any other creator, or anyone personally, is just ridiculous. You're forming opinions based on what you read on the page, as am I. We can have different opinions and even talk about those differing opinions and debate it without acting like a wide-open asshole. Because at the end of the day, it's all about opinion on both sides of the public arguments here. I feel like independent thought is becoming terribly underrated. And attacking someone you know personally, or interact with personally on a regular basis on behalf of rich celebrities who do not know or care about you is a little bit bizarre. It's kind of strange behavior in my opinion, but Anyways, the judge did rule on the extension issue. The deadline was moved to February 17th. However, that is a holiday here, so Blake Lively will have to file her amended complaint on the coming Tuesday, February 18th. In another recent development, Justin Baldoni's last name was mocked by a Hollywood agent who dropped him as a client amid the Blake Lively feud. This is what Hollywood agent Ari Emanuel said. It's a fucked up, bad situation with what Baldoni, whatever his name is doing. The Endeavor CEO, 63, said at a taping for Freakonomics Radio Live at the Wilshire Ebell Theater in Los Angeles, according to The Hollywood Reporter. Baldoni's lawyer Brian Friedman shot back, saying, "As I understand it, Justin hasn't been called baloney since the 5th grade. Perhaps Ari's perspective would be different if they had ever met in the half-decade they were clients of his agency." So that's some important context. He didn't even know the guy. Per THR, Emanuel confirmed he fired the Jane the Virgin alum. Justin Baldoni played, I think, Rafael Solano was his name on Jane the Virgin, and went on to gush about Lively 37 and her husband Ryan Reynolds, saying he's known them for a decade and they are incredible people. In Hollywood, they have been incredibly successful, the billionaire reportedly added. People work with them, they've never had any bad mojo out there or treated people badly. They are charitable, we help them with their foundation, and they've given tons of money away. So on the one hand, you want to hear more from people who actually know these parties so that you can get some background on different people's, character assessments of them. However, what he said doesn't entirely ring true here because there are a couple examples in this very article from page 6 that describe how Lively was, in fact, criticized for her behavior in the past. Despite Emmanuel's claims, an assistant director who once worked with Lively on A Simple Favor in 2018 just spoke out this week, claiming the actress was cruel and pushed her to tears many times. She said, "I know I cried my way home many nights because you try so hard to please someone who is never pleased and puts you down constantly." Now, I don't really know the context of that or what it was that she did to put this woman down. If there's any more information out there, I'll have to look into that. She went on to say, "I can't believe it's actually getting back at her. Karma is real." Also, ahead of the release of It Ends With Us last summer, Lively was called out for making an entertainment reporter want to quit her job after being a total nightmare during a press junket. Sounds like we're going to have some more to go through in this coming week, especially that amended complaint on Tuesday. We'll see what the judge says about those subpoenas. Thanks everybody for watching. Don't forget to hit the like button as it would really help out my channel, and I'll see you next time.